I will now invite all of you to listen, to hear out Mr. Jonas Ruškus, former United Nations Committee of People with Disabilities, who is recorded. Thank you for giving us an opportunity to hear, even though he couldn't participate today. The topic is about this. What international obligations rise from International Human Rights Convention for People with Disabilities, and what obstacles should be eliminated in this regard?
Hello everyone, dear participants of the seminar, dear justice system professionals, dear colleagues, scholars, representatives of civil society organizations. I would like first to congratulate you all for allocating time and space to discuss about access to justice for defendants with intellectual or psychosocial disabilities, or if I may add, about one of the most critical human rights issues in relation to persons with disabilities as a whole. The considerations that I am going to make today are based on my expert status at the Committee of the Convention on the Rights of Persons with Disabilities of the United Nations, or the CRPD as abbreviated, from 2015, including its vice chair from 2018 to 2022, when I finished my second and last mandate. The CRPD committee, like all other UN treaty bodies, plays a critical role in assessing the state parties' compliance with the international obligations as regards the realization of human rights and fundamental freedoms in the state parties. My role as a member of the CRPD committee consisted in the examination of the reports of the state parties of the CRPD on the implementation of the convention in the state parties, provision of them with recommendations for supporting them in meeting their international obligations under the CRPD, as well as the work on individual communications and inquiries in the state parties, elaboration of the CRPD jurisprudence as well. In addition, I played the role of a country rapporteur of the committee for many state parties, including Latvia, Estonia, Spain, France, Japan, Poland, and others. In addition to that, I would like to emphasize the most important role of the first-hand knowledge and experience at the work of the committee, which has strong partnership with the grassroots organizations of persons with intellectual or psychosocial disabilities in the state parties. In that context, I would like to use opportunity and to pay tribute to the most competent members and therefore my former colleagues of the CRPD committee, Mr. Gabor Gambos, a person with psychosocial disability, who, by the way, has unfortunately passed away last year. Ms. Diane Kingston from the UK, self-identified as a person with psychosocial disability, and Mr. Robert Martin, a person with intellectual disability from New Zealand. Contributions of all of them to the work of the committee have been the most significant and substantial. In the same way, close and active consultations with persons with disabilities in the development and implementation of legislation and policies through representative organizations of them is an obligation of the CRPD, Article 4.3 specifically. As about me in relation to intellectual and psychosocial disability, I have long experience of community-based living based on dignity of and relation with persons with intellectual or, in many cases, psychosocial disability. Today, my objective is to discuss international obligations to eliminate barriers to access for justice for persons with psychosocial or intellectual disabilities under the CRPD. During my 8 years of experience as an expert member of the CRPD committee, I observed how access to justice for persons with disabilities, particularly for persons with psychosocial or intellectual disability, remains one of the most challenging areas within the human rights and within the disability rights framework. However, very little progress is observed by the CRPD committee across all state parties of the CRPD in this regard. Within my presentation, I will focus on access to justice, the basic principle of the rule of law to guarantee equal treatment of all persons subject to it. As Article 14 of the International Covenant on Civil and Political Rights states, all persons shall be equal before the courts and tribunals. But specifically, I would like to focus on critical matters as regards access to justice for persons with intellectual or psychosocial disabilities. So the aim of my presentation is to recall the human rights standards in relation to access to justice for persons with psychosocial or intellectual disabilities. I will highlight systemic and structural barriers that seriously hinder access to justice for persons with psychosocial or intellectual disabilities, and I will identify determinants of these barriers, including boundaries of the principles of formal equality. Then I will focus on the main concepts and provisions of the CRPD and respectively the obligations of the state parties aimed at ensuring the realization of the rights to access to justice for persons with intellectual or psychosocial disabilities, with specific consideration of the principle of transformative equality in relation to the provision of procedural accommodations. To understand the issue of access to justice for persons with disabilities, we must understand the CRPD Convention. So a few words on the raison d'etre and rationale of the CRPD. 16 years ago, in 2006, the United Nations adopted the Convention on the Rights of Persons with Disabilities, the first legally binding agreement with the framework of international human rights law, setting standards for the rights of all people with disabilities, regardless of the type of impairment and intensity of support they may require. The CRPD, as an integral constituent of international human rights law, lays down obligations which states are bound to respect. By becoming parties to international treaties, including the CRPD, states assume obligations and duties under international law to respect, to protect, and fulfill human rights, including those of persons with disabilities on an equal basis with others. As observed by the CRPD Committee, persons with intellectual or psychosocial disabilities are among those who are the most subjected by deprivations of human rights, and as might be observed throughout the concluding observations of the CRPD Committee to the state parties. By adopting the CRPD Convention, states obligate to redress historical injustice faced by people with disabilities globally and to discontinue the structural and systemic discrimination on the basis of the impairment, resulting in the exclusion from communities from mainstream social relations into the margins of society. No new rights have been created by the CRPD. The Convention tailors existing human rights to ensure that all people with disabilities can fully and effectively enjoy them on an equal basis with others. The CRPD brought a global paradigm shift in disability policy and legislation and understanding of persons with disabilities from outdated discriminatory models of disability to the human rights model of disability. Under the outdated, the so-called charity and medical models of disability, persons with disabilities globally have been reduced to the objects of pity, care, treatment, or fixing, along with the impairment and incapacity-based perspective. Historically, charity and medical models of disability have been shaping all areas of life, including social, health, legislation, and policy areas, and resulted in the systemic social exclusion. For instance, under the charity and medical models, the substitute decision-making, treatment without consent, and forced confinement on the basis of impairment, psychiatric-based capacity assessment, social segregation through special education and institutionalization have been perceived and still applied as proper practices in relation to persons with intellectual or psychosocial disabilities, when in fact they deny human rights along with the international human rights framework. Contrary to charity and medical models, the human rights model of disability recognizes persons with disabilities as rights holders and human rights subjects, Article 1 of the CRPD states that the purpose of the CRPD is to promote, protect, and ensure the full and equal enjoyment of all human rights and fundamental freedoms by all persons with disabilities, and to promote respect of their inherent dignity. Thus, the human dignity, equality, and freedom are at the very essence of the CRPD and delineate the human rights model of disability. Any limitation of dignity, equality, and freedom on the grounds of impairment of a person constitutes a discrimination. The CRPD situates all persons with disabilities, regardless type of impairment and intensity, regardless intensity of support they may require, amongst the full set of human rights within international human rights law. As stated at the report of the Office of the United Nations High Commissioner for Human Rights in 2017, access to justice is a core rule of law. It is a fundamental right in itself and an essential prerequisite for the protection and promotion of all other human rights. Access to justice encompasses the right to fair trial, including equal access to and equality before the courts, and seeking and obtaining just and timely remedies for rights violations. Article 13 of the CRPD specifically addresses the obligations of the state parties in relation to the right to justice for persons with disabilities. Article 13.1 requires state parties to ensure, open quote, effective access to justice for persons with disabilities on an equal basis with others, including through the provision of procedural and age-appropriate accommodations, in order to facilitate their effective role as direct and indirect participants, including witnesses in all legal proceedings, including at the investigative and other preliminary stages. Close quote. Access to justice under the CRPD is a cross-cutting right that should be interpreted in line with its principles and obligations, and particularly when it comes to persons with intellectual or psychosocial disability, particularly in conjunction with the Article 12 of the CRPD on equality before the law, which requires state parties to recognize that all persons with disabilities, regardless of support they may require, that all people with disabilities enjoy legal capacity on an equal basis with others in all aspects of life, when in fact in practice, persons with intellectual or psychosocial disability are usually deprived of that right. Article 14 on liberty and security of the CRPD, which requires state parties to ensure persons with disabilities on an equal basis with others, that they are not deprived of their liberty unlawfully or arbitrarily. Existence of a disability shall in no case justify a deprivation of liberty, when in practice, in fact, in many states, mental health laws administrate deprivation of liberty on the grounds of psychosocial disability. And Article 19 on living independently and being included in the community, which requires state parties that persons with disabilities have opportunity to choose their place of residence on an equal basis with others, when in practice persons with intellectual or psychosocial disability are placed in residential care institutions outside communities and society. Moreover, an interpretation of Article 13 should take into account multiple and intersectional aspects of disability, particularly sex and gender, in relation to Article 6 on women and girls with disability and Article 5 of the CRPD on equality and non-discrimination, as well as the age in relation to Article 6 of the CRPD on children with disabilities. All these issues that I just mentioned constitute systemic and structural barriers to access to justice for persons with intellectual or psychosocial disability. I would like to highlight persons with psychosocial or intellectual disability face discrimination through structural patterns, such as including laws and policies, and systemic patterns, including within institutions that seriously hinder their human rights, perpetuate their social segregation and isolation, gravely affect their lives, including access to justice. More specifically, persons with intellectual or psychosocial disabilities globally and systematically are affected by substitute decision-making regimes and the denial of legal capacity. Legal provisions allowing decisions for removing legal capacity to a person are based on the diagnosis of cognitive impairment and respective consideration of decision-making skills of a person as deficient. Persons diagnosed as being unable to take decisions are denied the legal capacity. Substitute decision-making regime is imposed on them. Civil and political rights, including right to marry and found a family, to reproductive rights, parental rights, the right to give consent for intimate relationships and medical treatment, the right to liberty, usually are denied for individuals on the grounds of assessment of their capacities. Deprivation of legal capacity and substitute decision-making regimes prevent and exclude persons with disabilities from participating in legal proceedings by their representation by a third party, such as legal guardian. This leads to the exclusion of a person with disability from judicial processes and has adverse effect on the right to a fair trial under due process of law. Let me give you some numbers for the sake of illustration of the scale of impacted people by removal of legal capacity for them. According to the official data provided to the CRPD committee, for example, in relation to France, for the review by the CRPD committee in 2021, more than 700,000 persons were placed under various forms of substitute decision-making regimes, such as wardship and guardianship. In Hungary, which report has been examined in 2022, 55,000 persons with disabilities were placed under substitute decision-making regime in 2017. In Norway, there were more than 36,000 registered guardianships for adults and 21,000 guardianships for minors in 2015. As concluding observations of the CRPD demonstrate, these three countries are rather typical cases than exception among other states in Europe and globally. To note, substitute decision-making regimes furthers the deprivation of social, economic, and cultural human rights to persons with disabilities, particularly through the institutionalization, or in the words of the CRPD, I quote Article 19, obliging them to live in particular living arrangements, so-called institutions. There is a strong correlation between substitute decision-making and institutionalization of people with intellectual or psychosocial disability. For instance, according to the data received by the CRPD committee, there in Poland around 80,000 of persons with disabilities, including children with disabilities. In France, 100,000 of children, 200,000 of adults with disabilities are placed in various types of institutions. Indeed, these two countries are also rather typical cases than exception in Europe. Substitute decision-making regime and living in residential institutions including the lack of support and communication means and methods, become main obstacles for persons with psychosocial or intellectual disabilities for accessing justice. Furthermore, deprivation of freedom on the grounds of impairment is still a legitimized form of discrimination of persons with psychosocial disability that seriously impede access to justice for them. As stressed by the CRPD committee in its guidelines on Article 14 of the CRPD in 2015, paragraph 6, open quote, there are still practices in which state parties allow for the deprivation of liberty on the grounds of actual or perceived impairment. Legislation of several state parties, including mental health laws, still provide instances in which persons may be detained on the grounds of the actual or perceived impairment, provided there are other reasons for their detention, including that they are deemed dangerous to themselves or others, close quote. As observed by the CRPD committee, in all state parties reviewed, the voluntary or non-consensual commitment in mental health institutions, including non-consensual treatment during the deprivation of liberty, remain regular and legitimated practice through what is seriously deprives people of their human rights. Persons deprived of liberty on the grounds of actual or perceived impairments and placed in mental health institutions have no or have very little access to justice due to the lack of support for them for such attempt, as well to legitimacy and symbolic power of medical-based capacity assessment. Isolated from society in institutions, residential and psychiatric, persons with disabilities, as stressed in the report of the Office of the United Nations High Commissioner for Human Rights in 2017, open quote, are impeded from accessing courts and claiming their rights as a result of confinement to institutions, without recourse to outside contact to lodge complaints. In addition, lack of information on their rights and how to invoke them before courts and authorities pose barriers to seeking remedies, close quote. Moreover, negative stereotypes and derogative attitudes towards persons with intellectual or psychosocial disabilities reciprocally reinforce the medical-based disability assessments and consequently create legal barriers for access to justice. As consistently observed by the CRPD committee in its concluding observations to the state parties, the capacity assessment mechanisms perpetuate the discriminatory medical model of disability. These mechanisms, usually carried out by psychiatrists, but also lawyers, aim in fact the identification of the lack of capacities of a person, which once identified is employed assumingly as an objective reason for the denial of legal capacity by establishing substitute decision-making over a person, also by justifying the non-consensual institutionalization and treatment. Women and girls with psychosocial intellectual disabilities, including and especially those placed in residential institutional settings, are particularly affected by violation of integrity of the person through non-consensual sterilization and abortions, and usually observed by the CRPD committee within, as it is usually observed by the CRPD committee within its concluding observations to the state parties. In addition, declaration a person as non-liable or of unsound mind or insane, I use those terms in quotes, at the moment of the commission of the alleged crime resulting in exemption from criminal responsibility derives from the provisions allowing the denial of legal capacity, as well as from assessments based on medical model of disability. As stressed at the report of the Office of the United Nations of High Commissioner for Human Rights report, open quote, the individuals is then diverted from the proceedings and subjected to security measures entailing deprivation of liberty and treatment against his or her will, often indefinitely, thereby denying him or her the same due process guarantees as others, in violation of the right to a fair trial. Close quote. In the Universal Declaration of Human Rights, the principle of equality is about equal opportunities and equal treatment, by ensuring that no one is treated differently or less favorably on the basis of any characteristic or identity. Neither discrimination nor privilege is given to any social group under this principle, which is generally called a formal equality, the principle of formal equality. Formal equality requires that all persons who are in the same situation be accorded to the same treatment, and that people should not be treated differently because of the arbitrary characteristic, like case should be treated alike. However, such approach to equality should be criticized for its blindness to recognize people diversity, for its unresponsiveness to oppressive patterns in society, including indirect and unrecognized forms of discrimination, especially when they are embedded in the legislation. Under the legal framework based on formal equality, the discrimination of persons with psychosocial or intellectual disabilities through the capacity assessments, guardianship regime, deprivation of freedom on the grounds of actual or perceived impairment, and institutionalization remains intact and frozen. For persons with psychosocial or intellectual disability subjected to systemic discrimination, the attempt to show being a victim of discrimination under formal equality shape usually is mission impossible. Formal equality as a principle of the rule of law neither protects persons with psychosocial or intellectual disabilities against systemic or structural discrimination, nor is sufficient to ensure their fair and equitable treatment in the administration of justice, including access to justice. In contrast, the principle of substantive equality is based on the acknowledgement of differences between people, their diversity and variety of their identities. Moreover, the principle of substantial equality includes the recognition of power relations and the systemic and structural nature of inequality. According to Goldschmidt, I quote him, in the substantive equality approach, we can't be blind to differences because differences should be taken into account. In this regard, Friedman proposes a four-dimensional approach to redress disadvantage, address stigma and stereotyping, prejudice and violence, enhance voice and participation, and accommodate difference, so achieve systemic and structural change. By requiring social structures to change, to accommodate differences, including by elaborating on duties of accommodation, the principle of equality assumes the transformative dimension. Teresa Degener, the former member and chair of the CRPD committee, links the principle of transformative equality with the human rights model of disability, pointing out that it provides the roadmap for changes. And as later reaffirmed by the subsequent chair of the CRPD committee, Ms. Rosemary Case. The CRPD explicitly brings up that access to justice for persons with disability, particularly for persons with psychosocial or intellectual disabilities, must be considered from the lens of both the human rights model of disability and the principle of transformative equality. For transformative equality to be achieved, many rules, laws, and procedures need to be revised and changed to include procedural accommodations for persons with communication disabilities in order to enable them to participate effectively in the court system. Accessibility of jurisdictional systems for all persons with disabilities, with specific emphasis on those placed in residential institutions and psychiatric settings, as well as the availability of multiple means and formats of communication within the jurisdictional systems constitutes a part of the human rights model of disability. What are obligations laid out under the CRPD? What are recommendations by the CRPD committee aimed at facilitating and putting into effect the human rights model norms and standards of the CRPD as regards persons with intellectual or psychosocial disabilities? I would like to touch upon the issues that I just mentioned above and to clarify the necessary policy and legal transformations, positive actions, and support measures in relation to the CRPD standards as recommended by the CRPD committee. Within the general comment on Article 5 on equality and non-discrimination, the CRPD committee stressed, I quote, State parties must ensure that all persons with disabilities have legal capacity and standing in courts. To ensure equal and effective access to justice, substantial rights to legal aid, support, and procedural and age-appropriate accommodations are essential. Under Article 12 of the CRPD on equality before the law, state parties are obligated to refrain from denying persons with disabilities their legal capacity to abolish, as usually is expressed by the CRPD committee in its concluding observations, the substitute decision-making systems and must instead provide with access to persons with disabilities to the support necessary to enable them to make decisions they have legal effect. Through the supported decision-making mechanisms that support a person with disability in the exercise of their legal capacity by respecting the rights, wills, and preferences of a person. As clarified by the CRPD committee in its general comment on Article 12, states parties must also ensure that persons with disabilities have access to legal representation on equal basis with others. This has been identified as a problem in many jurisdictions and must be remedied, including by ensuring that persons who experience interference with the right to legal capacity have the opportunity to challenge such interference on their own behalf or with legal representation and to defend their rights in courts. In the same way, about persons subjected to non-consensual commitment in mental health institutions and treatment, as indicated in its guidelines on Article 14 of the CRPD on liberty and security, the CRPD committee has called on the state parties to protect the security and personal integrity of persons with disabilities who are deprived of their liberty, including by eliminating the legal provisions for and the use of forced confinement and forced treatment, seclusion, and various methods of restraint in medical facilities, including physical, chemical, and mechanical restraints. Furthermore, as stressed by the committee, persons with disabilities are arbitrarily or unlawfully deprived of their liberty are entitled to have access to justice to review the lawfulness of their detention. A, by ensuring procedural accommodations and the provisions of accessibility. B, by providing the required and appropriate support to exercise the legal capacity with respect to proceedings related to the detention and in the detention setting itself. C, by providing the opportunity to promptly stand trial with support and accommodations as may be needed, rather than declaring such persons incompetent. D, by providing the information about ways in which people can effectively and promptly secure their release, including adjunctive relief. E, assistance programs centered on the provision of mental health services or treatment, free or affordable community-based services, including alternatives that are free from medical diagnosis and interventions. F, providing with compensation as well as all other forms of reparations in the case of arbitrary or unlawful deprivation of liberty. Furthermore, the CRPD committee calls the state parties to revise criminal procedures to repeal the concept of non-liability, as well as any version of the insanity defense, and ensure access to justice for persons with psychosocial disability through giving them the opportunity to stand trial promptly with necessary and required support and accommodations, rather than declaring such persons incompetent, non-liable, or imprisoning them into closed settings without fair trial and under conditions of forced and indeterminate treatment. In addition, as stressed in the CRPD committee's guidelines on deinstitutionalization, including in emergencies of 2022, access to justice, particularly for women and girls living or leaving institutions who experience gender-based violence, is a key in deinstitutionalization. In the guidelines, the CRPD committee recalls that all barriers, including legal and procedural barriers, should be removed across all legal domains, that procedural accommodation should be made available, that legal standing in courts and tribunals and the provision of free and accessible legal representation should be ensured. Open quote from the guidelines. Releasing persons with disabilities from disability-based detention and preventing new detentions are immediate obligation and not subject to discretionary judicial or administrative procedures, close quote. Besides removal of above-mentioned structural, including legal and institutional obstacles to justice for persons with intellectual or psychosocial disabilities, the provision and availability of procedural and age-appropriate accommodations plays a key role in ensuring access to justice for all persons with disabilities, particularly for persons with psychosocial or intellectual disabilities. It serves, as stressed in the report of the Office of the UN High Commissioner for Human Rights, open quote, as a means for effectively realize the right to a fair trial and the right to participate in the administration of justice, and are an intrinsic component of the right to access to justice, close quote. Namely, Article 13 of the CRPD emphasizes the obligation of the state parties to provide persons with disabilities with procedural accommodations for guaranteeing an effective access to justice for persons with disabilities on an equal basis with others, and the facilitation of the effective role in all legal proceedings. In addition to the above-mentioned, Article 13 must be also read in conjunction with Article 5 on equality and non-discrimination and understood as a duty of non-discrimination. In its concluding observations for state parties, the CRPD Committee consistently expresses its concern about the lack of reasonable accommodations for persons with disabilities and recalls to provide them with all necessary and required reasonable accommodations in all stages of legal proceedings. Communication barriers, mainly arising from medical model of disability, constitute the major lack within the procedural processes. As emphasized at the report of the Office of the UN High Commissioner for Human Rights, open quote, the determination of the need for procedural accommodations should be not necessarily be based on medical information and cannot be subject to any disability assessment, close quote. Medical model that grounds the discriminatory assessment of the capacity to understand and fitness to stand trial applied exclusively to persons with disabilities may lead to the involuntary treatment and detention of a person with psychosocial or intellectual disability, but also to hinder equality of access for them in legal proceedings. As declared by the Working Group on Arbitrary Detention of the United Nations, persons with psychosocial disabilities must be given the opportunity to stand trial promptly with support and accommodations rather than declaring such persons incompetent. Such practices of assessment of capacity to understand, including by declaring of a person as being incompetent, are considered as discriminatory on the grounds of impairment, are strongly criticized by the CRPD Committee, and to be replaced by supported decision-making mechanisms and procedural accommodations. The CRPD Committee further recommends that the state parties define the entity responsible for providing procedural accommodations and include the details on where and how persons with disability can request and access them. Communication methods are an essential part of procedural accommodations. The lack of communication methods may seriously prevent for persons with disabilities, psychosocial, intellectual disabilities, the access to information, understanding the legal procedures, and the exchanges with judges, lawyers, prosecutors, and other interlocutors. There are various and multiple modes and methods of communication that facilitate the communication and ensure access to justice on equal basis with others. Easy to read, plain text, symbol systems, also accompaniment by independent intermediaries and facilitators, such as support persons, autism referent persons, in case of person is autistic, may substantially facilitate the communication in the judicial proceedings. Procedural accommodations, including the availability of communication methods, must always be available and provided free of charge to ensure that jurisdictional systems are inclusive and accessible for all persons with disabilities. As regards the detained persons with psychosocial intellectual disability, the state parties of the CRPD are obligated under Article 14 on liberty and security to ensure that they are treated in compliance with the objectives and principles of the Convention. In other words, the human rights model of disability, including by provision of reasonable accommodation. In conclusion, persons with intellectual or psychosocial disabilities are among those the most discriminated on the grounds of their disability and the most excluded from society by various structural and systemic factors, including by legal frameworks that, in one hand, uphold discriminatory medical model of disability by means of substitute decision-making regimes and the denial of legal capacity, forced treatment and deprivation of liberty on the grounds of actual or perceived impairment, by capacity assessment mechanisms, by institutionalization of persons with disabilities. The human rights model of disability must become an integral part not only of international but also national judicial and legislative frameworks for ensuring their non-discrimination and equality on equal basis with other people. Also, in effect, aiming the liberation of persons with intellectual and or psychosocial disabilities from oppressive structural and systemic conditions. The concept of former equality must be reconsidered. The concept of transformative equality must be embraced for ensuring access to justice as fundamental human right for persons with intellectual or psychosocial disabilities, including but not limited by reasonable accommodations, alternative and augmentative modes of communication, support persons, and many other empowering means. And that brings us to the end of my presentation. I'd like to thank you all for your time and attention today. By the way, on my slides, you will find references the list of references that I used for my presentation. Thank you again. And goodbye.
And now,
I would like you to take your seats, either physical seats, those who are with us here today, and or those who have joined us remotely. Also take your seats. Let's go further on.